Presidency dismisses U.S. court order on Tinubu's alleged drug probe record as nothing new. It's nothing new. Okay now. The Bola Tinubu presidency has dismissed concerns over a recent judgment by a U.S. federal court directing American law enforcement agencies to release investigative records related to President Bola Ahmed Tinubu, asserting that the document contains no new revelations. The rulings issued by Judge Beryl Howell of the U.S. District Court for the District of Columbia compels the Federal Bureau of Investigation (FBI) and the Drug Enforcement Administration (DEA) to disclose records of a reported narcotics investigation from the 1990s. The judge rejected the agency's use of glomar response, a legal tactic allowing U.S. agencies to neither confirm nor deny the existence of sensitive documents. As grounds to withhold the records. In response to the judgment, President Tinubu's Special Advisor on Information and Strategy, Bayo Onanuga, stated on Sunday that the administration has nothing new to say on the matter. Don't say anything now. There is nothing new to be reviewed, Onanuga said. Okay, you think so? But the ones that have been reviewed, The ones that have been reviewed already, there is nothing new that needs to be reviewed. These people, The reports by Agent Moss of the FBI and the DEA report have been in the public space for more than 30 years. The reports did not indict the Nigerian leader. The lawyers are examining the ruling, he said. He added that media inquiries about the presidency's reaction were not unexpected, but emphasized that the administration remained unshaken. Journalists have sought the presidency's reaction to the ruling last Tuesday by a Washington, D.C. judge, ordering the U.S. FBI and DEA to release reports connected with the president, Bola Ahmed Tinubu. Our response is as follows. There is nothing new to be reviewed, he reiterated. What if they have something new to be reviewed? What if? Meanwhile, the case could potentially shed more light on long-standing controversies surrounding President Tinubu's past. President Tinubu, who assumed office in May 2023, has consistently denied any wrongdoing regarding the decades-old allegation. And so now they deny now. That's how people deny every time. The Nigerian government maintains that the matter has long been settled and poses no threat to the president's legitimacy. What has been settled? The fact that he's a drug baron, it has been settled. This is why Onanuga, please. Earlier, Sahara reporters reported that a U.S. federal judge has ordered the FBI and DEA to release investigative records relating to the Tinubu stemming from a purported narcotic trafficking investigation in the 1990s. According to Premium Times, Judge Beryl Howell of the U.S. District Court for the District of Columbia handed down the order on Tuesday, rejecting the government agency's attempt to withhold the documents under the so-called glomar response, a policy allowing agencies to refuse to confirm or deny the existence of records. The claim that the glomar responses were necessary to protect this information from public disclosure is at this point neither logical nor plausible. Judge Howell wrote, affirming that both the FBI and DEA failed to justify their refusals under the Freedom of Information Act. Why did you refuse to not release it? Oh yeah, release it now. The case was initiated by Aaron Greenspan, an American transparency advocate and founder of PlainSight.org, who filed a lawsuit in June 2023 after submitting 12 FOIA requests to various U.S. law enforcement and intelligence agencies. This request sought details of a federal investigation into a heroin trafficking network allegedly involving Tinubu and others, including Abiodun Agbele, Maurice Akonde, and Lee Andrew Edwards. Greenspan's FOIA requests were earlier denied by the FBI, DEA, Internal Revenue Service (IRS), Department of State Executive Office for U.S. Attorney (EOUSA), and Central Intelligence Agency (CIA), all of which invoked glomar responses. In his lawsuit, Greenspan argued that the agency had improperly withheld information of significant public interest. He also cited a verified complaint filed by the U.S. Department of Justice in 1993, seeking the forfeiture of $460,000 in funds linked to Bola Tinubu, which the U.S. government alleged were proceeds of drug trafficking. The court documents include an affidavit by Kevin Moss, a special agent with the IRS at the time, who detailed the activities of a heroin ring operating in the Chicago area. The affidavit indicated that Tinubu was being investigated in connection with financial transactions that allegedly laundered proceeds from the narcotic trafficking. There is probable cause to believe that funds in certain banks were controlled by Bola Tinubu, were involved in financial transactions in violation of US laws, and represent proceeds of drug trafficking, Moss stated in his sworn affidavit. The same affidavit tied Tinubu to Muiz Akande and Abiodun Agbele, noting that Agbele, arrested after selling white heroin to undercover DEA agents, cooperated with investigators and revealed further links within the network. In response to the FOIA lawsuit, President Tinubu intervened in October 2023, citing privacy concerns and objecting to the release of confidential tax records and documents from federal law enforcement agencies. However, Judge Howell ruled that the public interest in understanding the records surrounding Tinubu's alleged involvement outweighed the privacy interest claimed by the president. Abi? Yes, they need to show us. The public interest in learning about a sitting president's possible connection to a major drug investigation is undeniably significant, the judge wrote. Yes, so thank you, Judge. Although the CIA successfully defended its global response, with the court ruling that Greenspan's failed to show that the agency had officially acknowledged the existence or non-existence of responsive records, the judge ordered all other agencies, excluding the CIA, to jointly file a report on May 2 on the status of the outstanding issues in the case. The forfeiture of the $460,000 in 1993 surfaced during the 2023 Nigerian presidential election as opponents of Tinubu questions his eligibility. However, Nigeria's election tribunal ultimately dismissed those challenges. It is well. It is well. Reacting to the U.S. court's decision, Greenspan said in a statement, transparency must prevail over secrecy. Thank you. When it comes to public officials, the American public as well as Nigerians, we deserve to know the truth. Abi? We deserve to know the truth though. Please tell us the truth. Really. Give us the information. Let us see what this person is truly about, who this person truly is. It is well. Uche really says, this is one of the reasons why one Professor Bolaji Akinwumi said a few months ago that Tinubu should avoid direct confrontation with Trump. Yes, so oppositions are planning to use this issue against Tinubu in 2027, but it has come earlier. Tinubu's domestic worker, like Bayononuga domestic worker, should know that this is not our Supreme Court matter here. Yes, so where Wike is in charge. Let's see how it's going to end exactly. These ones are going to spill the truth, whether you like it or not. If you like, try to bribe them. It's not even going to work. They are going to expose you the more. That's just it. So, my listeners, over to you. Leave your thoughts in the comment section. Don't forget to like, to share, and subscribe. Thank you for listening. See you some other time. Bye.